Okay, last week I'm sorry that so many of you were unable to get here because of our inclement weather, but I guess what could we expect in the middle of February? For those who weren't here last week, and for those who may have some concern as to what materials you're supposed to have, let me tell you that you've got a book that is in two parts. Your first part is the lecture part. It doesn't have a table of contents as yet, so don't worry if you don't see it. It is coming. We're waiting for the contents. The first thing that you will have in that book is the introduction. The next thing you will have is a copy of Rule 2. The next thing you will have is your list of reference materials. And the next thing you will have is Lecture A, Brian Bucknall's lecture on cases, what's new in cases and statutes. The next thing you'll have is B, Ian White on billing and timekeeping and record keeping. And at the end of that, you will have the material that Alan Marshall gave us from the Practice Advisory Service. That's two pages. Following that, you'll have Lecture C, Brenda Duncan talking about what your client should know. Lecture D, the lecture by Lorraine Setterington, the surveyor. And at the end of that, I would suggest you put your long spate sketch. That's the sketch as it was drawn by the surveyor. And facing that, the short one that Lorraine Setterington gave us to show us the difference in 20 years of what's on a survey then and now, and why they won't take old surveys. Now, last week you didn't get any lectures given out to you because our lecturers were shy. So this week you should have the next two lecturers. You should have Don Donahue's lecture. Let me see, what are we at? A, B, C, D. That's E. And Wayne Rosenman's, which is F. And for those who weren't here last week, the lecturers referred to their written material, referred to the fact situations and the agreements of purchase and sale which faced them, and we worked out our agreement of purchase and sale in both cases. Today, you've been given not only those two lectures, but the lectures for today. And I'm lost again. A, B, C, D, E, F. That's G and H you've got today. Added to H at the end is a page called H17. In the course of preparation, we discovered there was one more search we better make. So H17 is the page which was added. And that's what's in your lecture part. Following the lecture part, you have a buff page, and you've got the workbook part. This is where we apply the theory in the first half. So after your buff marker, you start with a page numbered 1 without a letter in front of it, and that's your listing agreement. Followed by your fact situations, and each fact situation faces the agreement of purchase and sale, which is expected to come out of it. That was pages 1 to 30. And the next thing you got were pages 31 to 101. Now in there, you'll notice you've got two pages 100. Page 100 is the sketch that relates to the land that we're buying, the city land that we're buying. And so you'll have two of that. You'll have the one that was included with your material, and you have the extra one that was a handout so that we could work with Lorraine Setterington. So you will have two copies of page 100. Now, some of you have told me that you couldn't find the added facts. I now know why you couldn't find the added facts. They were at the end of Lecture D. So those of you who have not found the added facts, I hope you weren't gypped. I think they're at the end of Lecture D. And they're called addenda. Today you've been given Again, we're trying to keep you 1 week or so in advance. You've been given the requisition material so that you'll have in your workbook pages 103 to 114, which deal with requisitions, and a bunch of blank documents, pages 115 to 232. We are assuming that you've read the facts. We're assuming that you've read the additional facts. We're assuming that you have, if you weren't here last week, you did it on your own. If you were here last week, you did it while we were taking the lectures, filled in the agreements of purchase and sale. And we're now ready to look at the search. And you'll find your search starting on page 86 of your workbook. And that's where we're going to begin today. As follow-up from last week, I have 2 or 3 things to tell you. One, the tax chart which you found at page 34 of your workbook, that's the back half of your book. It looks a little like a graph. The original one didn't have as much information as the one that you were then handed last week. It shows the jurisdictions around the Toronto area and the months of the year. If they had a date already fixed for their taxes, we've put it in. If they just told us that we have a month but no date fixed, we filled that in too. Apologies, King City is not King City, it's King Township. And one of you was kind enough to tell me that there is a change in the address on page 36 of your workbook, Whitby. I'm told that instead of 405 Dundas Street West, we write to 575 Rossland Road East. Anybody know whether that's Whitby or Oshawa? That's Whitby. Thank you. Also further to last week, Wayne Rosenman promised he would give you a case name. Here it is. It has to do with the right of the residential landlord to terminate for sale purposes. And one of you asked a question, can the landlord terminate if he wants to sell? And Wayne says, look at Recayer, C-A-Y-E-R, and Levac, L-E-V-A-C, 1979, 23 OR, second series, at page 526, a county court decision. He also mentioned reference to an article written by his partner, Malcolm Archibald. For those of you who were left hanging as to where it can be found, it was last year's March special lectures, the blue volume that the Law Society puts out. You've been given your green evaluation sheet. Looks like this. If you'd start filling in your general comments, that's paragraph 5, and just keep your running commentary. You can fill in the top part as you wish and when you wish. This course, slightly different with different lecturers and a little different material, has already been run in Ottawa and London and Sudbury. And I saw the commentaries from London. I hope you don't do this to us. The commentary said, course too long, course too short. Course too hard, course too easy. Went too fast, went too slow. Should have had more handouts. Why did you give us all this paper? So I expect that we'll hear from you, as I say, right from the heart, including the comments that are negative, because only when we find out as well what you don't like as what you do like, can we fix it up. Now, one of the things you don't like is me going on and on, so I'm just about to finish. As soon as I introduce those pieces of paper which have to do with searches That's one of the kinds of maps that I think Rick is going to be speaking about. You can get them from the ministry at about $2 each for a variety of counties. That's the list, I believe that is the list of topographical maps which are available. That's another index to various other maps which the province supplies for an average of $2 to $2.50. They also have maps of the province which are free and a map which I think Tony's going to show you later. Now, enough introduction. Let us get to our search and our search of title. And we're going to be hearing about the search generally and about that search specifically from D. Rick Angelson from Castlesbrock. I told you we had people from small firms and large firms, and I think Castlesbrock, you could call it a small large firm or a large small firm. And Rick, who is a UC grad and a grad of the University of Toronto's Faculty of Law, was called to the bar since '74, and as far as I can tell, he's been rushing madly to this lecture ever since. Rick?
I consider myself a small person from a large firm, so perhaps put me in my proper place. The earlier speakers dealt with the agreements of purchase and sale, and while we considered that a very worthwhile topic, in the real world, we rarely get to see the agreement of purchase and sale before it's been executed. We often use that to blame the agents on any problems that may arise at a later date, but it's obvious that all of us are going to be involved in the searching of title. It is here that we are most vulnerable. First of all, we have to decide what it is we're going to search. Now, in the perfect world, the agreement will have all the information we could possibly want. It'll have a legal description and a survey. That's the perfect world. That's not the world that we practice in. In the world that we practice in, we'll most likely be provided with a municipal address and not much more. We have to remember that time is running. Time starts to run as soon as the agreement is executed, and our time for requisitions is passing us, so that we have to have at our hands the tools to allow us to determine what property is that we're going to be involved with and what we're going to be searching. The first thing we'll do, obviously, is contact the solicitor for the vendor, try to get from him the pertinent details. We're going to ask for the legal description, survey, the last instrument perhaps by which the vendor took title, and the name of the vendor. However, the solicitor for the vendor may have some, all, or none of that. We then often find ourselves in a position where we're asking for an extension for the time to submit our requisitions. While that's a wise practice, I think we still must understand that the clock is continuing to run. Many solicitors have tried to use the fact that I was unable to provide the pertinent details to them so that they could do the search as a reason for their getting an extension for requisitions, and of course that just doesn't wash. You are on your own, and although you may find that the solicitor for the vendor is cooperative and is prepared to give you that kind of extension, it's certainly not yours as of right. If you're going to get an extension from him, you better make sure that it's confirmed in writing, because often we are dealing with the solicitor's secretary or someone else in the office who may not have the authority to do what he's trying to do. So assuming we can't get the pertinent information from the solicitor, the next step we might try is a trip to the assessment department. Now, the assessment office, given that you have the municipal address, will most likely be able to provide you with a short legal description. The difficulty with the assessment department is that they generally will not answer requests over the telephone, so that if you're dealing with Toronto property and your office is in downtown Toronto, you're fine. Any other piece of property, and it's going to involve sending somebody out to the local municipality to get the particular information. Hardly a particularly good piece of news for you. Most in the Metropolitan Toronto area subscribe to TILA. TILA will provide you for a fee with the information that's in their records, so that you phone them up, give them the information you have, and they will provide you with a short legal description. Again, they'll provide you with a short legal description if they have it. They don't always have it. Often is a little harsh. Perhaps sometimes we've found that the legal description they provided us with is incorrect. The last method that may be used is a method of taking the municipal directory and the maps which are available to you in the registry office. Taking the municipal directory and trying to determine where your property is in relation to streets. Having found intersecting streets and having been able to locate your property with some degree of certainty, you can superimpose that on the maps which are in the registry office, determine therefore what plan it is you're on, and get a range of lots within which you should be able to find your specific property. Now we've presumably been able to determine what it is we're going to search. Where do we search it? It's fairly trite, but all plans that begin with M are in the land title system. Others, presumably then, are going to be in the registry system. I have had a great deal of difficulty determining with certain properties which registry office they're in fact in. There is a bulletin from the Director of Land Registration indicating which of the registry systems you'll find your particular property. Again, if you're in the heart of downtown Toronto, that's not a problem. But if you're on the borders of some of the boroughs, you might find that Scarborough is an area where some property was at one point registered in the borough of Scarborough and now is in Whitby, or vice versa. Similarly, Newmarket has now expanded its offices. I personally have a great deal of difficulty with Brampton and Orangeville. I can never determine which of the two offices I'm supposed to be involved with, and if my conveyancer is silly enough to listen to me, I may send her to the wrong office. Having now determined where we're supposed to go, what do we send our searcher with? Wherever possible, you should send your searcher out with a copy of the offer. That seems obvious, but with a copy of the offer, the searcher is going to be aware of the requisition date and understand then the time limits in which he's working. The searcher will also be aware of whether there are mortgages to be assumed or discharged. Many of the searches that we get back, if we have not taken the time to provide our searchers with the appropriate detail, we'll have all sorts of details about mortgages that are going to be discharged. Personally, I'm not particularly concerned as to whether the mortgage is for 6% or 20% if it's coming off. However, if the mortgage is going to be assumed, then I'm obviously much more concerned with the due execution of it, the interest rate, and any prepayment privileges that may exist, and I probably will want a copy. The searcher also, given she has a copy of the agreement of purchase and sale, will be directed to looking for things like rights-of-way, mutual driveways, items of that nature that may not in a first instance appear to the person unless the survey is available. As well, of course, the description, which may or may not be in the agreement of purchase and sale, is going to be of utmost importance to the searcher. Now, the debate still runs on where we start our search in the registry system. However, the better opinion still seems to be that we begin our search with the first good root of title, registered at least 40 years prior to our closing. Now, if we can even agree on that, we still may not be able to agree as to what a good root of title is. The prevalent opinion still seems to be that an executor's deed and a deed under power of sale, instruments of that nature, are still not accepted as good roots of title. However, I must say that opinion is not held unanimously. There are, again, certain exceptions even to the 40-year period. A certificate given under the Certificate of Titles Act is considered as a good root. A tax deed by many people is considered a good root, and a deed under the Veterans Land Act. Having stated that those are the exceptions, I'll now qualify the exceptions. The certificate of title given is dated and often isn't registered until some number of days after its date, and obviously any intervening registration would be important. The Vendors Land Act is itself perhaps an unconstitutional piece of legislation. While we have a case which indicates that it is a good route for conveyancing purposes, it may be that the whole act itself is unconstitutional. Tax deeds, we have been satisfied generally that the Tax Sales Confirmation Act has confirmed tax sales that have taken place during the applicable periods. However, in 73, a case called Curtin and Frolic was decided, which has now put people in a position where they're doubting the authority of a tax deed. In the Curtin and Frolic case, briefly as I recall it, some predecessor in title sold the property And then he got such a good deal, he sold it again. And the second party, perhaps realizing that he didn't own the property, didn't pay taxes. The property was then sold for taxes, and then some subsequent purchaser many years down the line raised the requisition that this wasn't a good route of title, given that the person who'd defaulted on his taxes never owned the property to begin with, and that was upheld. I suppose if we just relied on looking at the tax deed itself, there would be nothing on the face of the tax deed to lead you to the conclusion that there was something improper. So we leave you with those little bits of advice. What information now are we supposed to take from this search? The notes you'll see indicate that we're to go back to the Crown patent. I'm not sure how many of us actually do that, but the Crown patent is going to advise us as to what reservations there would be for mines and minerals, and it may be of great importance to us in a very major transaction. Remember that the Crown patent is, of course, subject to certain provisions of the Public Lands Act, which will deny the reservation of various mines and mineral rights. Also, if you are of the opinion that the Crown patent really doesn't have much to do about land these days, you may be interested in reviewing the provisions of the Registry Act, which provide that there is no protection under the Registry Act for any land which isn't patented. So that if you don't have a Crown patent to begin with, I guess we're not going to bother much with the provisions of the Registry Act. We are stuck with actual notice of all those instruments that have been registered, and of course then we must review and examine and decide for ourselves whether any of the or all of the registered instruments are going to pertain to our title. When we say registered instruments, obviously then we don't mean deposits. Deposits are not registered. Deposits are filed. They have no registration number. No one has actual notice of the deposit until such time as it's been read. Having said that, the standard of practice is such that no one doesn't read a deposit. And I think you might find yourself hard-pressed to deny the contents of a deposit if, in fact, it had been registered. Having gone through the various instruments, we then prepare a chain of title. The chain of title will then show us how title has evolved to the registered owner. We should check it to see what breaks there have been in the chain. Are there parties which somehow appear out of the blue dealing with the property? All this which should be detailed in your chain of title. As a check to see whether there are any instruments that you have failed to consider, it's suggested that you take one more stab at the search, and perhaps with the use of a ruler, go down the abstract page and stop at each instrument and consider not so much whether it must be entered in your search, but is it an instrument to which you drew attention? And presumably with this second search or the second check, there won't be a situation where certain instruments may be missed. Having done that, we now have to turn our attention to the description itself. If we have been provided with a survey, then we will have perhaps an easier task of dealing with the description that we're in fact searching. However, in any event, we must make certain that the description that we're dealing with is sketched on the plan of subdivision or the township lot. We will make further reference to that when dealing with the Planning Act. Having done your little sketch, you're now in the process, I would think, of comparing that description against the agreement of purchase and sale. Obviously, you want to make certain that the property you've been bothering yourself with searching is in fact the one that you're supposed to be buying, but also to compare that description with the descriptions of other instruments in the search, and to determine whether there's any overlap and determine whether the description has itself been consistent throughout. At the same stage, you may want to concern yourself with access that is to your property. It's certainly the case that roads are vested in municipalities by virtue of the registration of a deed, or by virtue of the application of Section 78 of the Registry Act. Under that section, if the road is the only access to a lot on a plan of subdivision upon the sale of a lot, that road becomes designated as a highway. That's fine, but of course the plans can be changed before a lot is sold, so that once just looking at the plan of subdivision won't be enough, in that it may have been revised. But once the lot is sold, then you can make certain that that road has at least, that road on the plan has at least vested in the municipality. However, the opinion seems to go on to indicate that perhaps that's not enough. That is, the municipality must, by bylaw or by expending money, have assumed some responsibility for the road. In the notes, I refer in part to a dispute that I'm having with one of the local municipalities, and it concerns a situation where, if you can envisage a square, four squares forming a sort of a checkerboard with roads running up and down on either side. One of the roads is opened and used all the time. The other road has never been opened and in fact is just a field. If one was to look at that and not be advised by, when I say it was a field, I'm exaggerating to some extent because there is a track there that people take their motorbikes and things on. So there appears to be a road, but it's never been paved, graveled, or any such thing. If someone were to try to purchase the lot in the far corner of that is the lot which runs alongside this road, he may be under the impression that there was in fact a road that the municipality had taken some care with. That would be wrong. If his lawyer just looked at the provisions of the Registry Act and considered that that was a road on a plan of subdivision, a lot had been sold, the lawyer may be under the impression that there is in fact a road and proper access. I don't know what the answer to our war will be. If I were lecturing later in March, I might be able to give you that answer. But for the moment, the municipality is taking the position that it's under no responsibility whatsoever for that road. So that if our searcher had found, of course, a bylaw, or we were in some way able to determine that money had been spent on the road, we'd have a very easy time of it. Also, in dealing with plans of subdivision, we must have a look to see whether the 1-foot reserves have been dedicated. We'll be checking for road windings. And we should remember that there's a page at the end of the lots for roads and for reserve strips. And if you're in doubt as to what has happened with the 1-foot reserve, there should be a page there dealing with it. Rights of way also seem to constitute a bit of a problem for certain people. It seems from my experience that when we're dealing with something like a cottage property, where there's a road of some 600 or 700 yards in from the main road, no one seems to overlook the fact that that should be searched. We should make sure that access to the cottage can always be maintained and that there's proper title. However, when we deal with a similar right-of-way, which may be a mutual driveway or a right-of-way as between two adjacent properties, my experience has been that not the same kind of care is taken. Again, I briefly refer in the notes to a case that I'm involved with a solicitor who was faced with searching the title to a particular piece of property, which was subject to a right-of-way in favor of the neighbor to the east for purposes of motor vehicle transportation, but included a right-of-way to draw water from a well which was located on the other property. He searched the title to the property that he was dealing with, and everything seemed to be in order. Unfortunately, he didn't search the property to the east, and when the property was sold, the new owner turned off the well and said, "It's the first I've heard of water. I see there's a well here, and I've been driving my car across your driveway and so on, but there's no reference whatsoever in my title documents to you having any right to draw water." And he happened to be correct. There we were. If the solicitor, I guess, had the foresight to search the property over which the other right-of-way had been running, there wouldn't have been any difficulty. Having done all of the foregoing, we're still must remember to search the fee book, make sure that we have got all the instruments that are dealing with that particular property. Having completed that part, we should date our search and indicate the last instrument that was noted in the search, so that when we come to update the search for closing, we won't have to be fumbling around through pages of searches in the abstract book that we've already been through. The search still is not over. Corporations, we used to, when we were faced with a Corporations Tax Act, be very concerned with determining which corporations owned the property and during what periods, and then we'd write to obtain clearance with respect to any existing liens. Now that that has been taken away from us unless the lien is registered, we seem to have forgotten about corporations. However, we should remember that to the extent that the corporation was not in existence at a particular time, the property may very well have is cheated. And in the event it's cheated, we certainly have some difficulty conveying good title. You should also be aware of certain provisions of the Mortmain and Charitable Uses Act dealing with charities and the 2-year rule, which may cause vesting of a property which had been conveyed to a charitable use, which has not, in fact, been sold within that 2-year period. Next, we should be searching executions. Taking the chain of title that we presumably have prepared, we are going to search executions against all those shown in the chain. You should remember that that executions which are greater than 20 years old are not going to be, you won't be able to get answers to them without attending, as I understand it, at the registry office and getting a list which deals with just those executions. I mention executions because of 2 recent experiences in our office. One, and both of them dealing with out-of-town firms. One where we had asked for a search to be done and got back the search notes, and it was noted something to the effect that, of course, it's not our practice to search executions. And we then had the search and had to sort of do it ourselves, go through the names and write off to the sheriff and send them the appropriate amount of money to get the answer for executions. I found that hard to understand, that someone made it his practice not to search executions. Then we were closing a deal with another firm, also not from the same center but out of town, and we had not acted for the vendor, and the solicitor for the purchaser on closing then raised with me certain problems relating to executions dealing with prior owners. And I sort of at a loss because it appeared as though they were valid requests. Whether those were in fact the parties that we were dealing with or not, I didn't know. But I found it rather embarrassing when he called me at this time, and I asked why he hadn't bothered to tell me about this earlier. And he said, it's not our practice to search executions until closing. I said, thank you, and hung up. Again, let me emphasize that you're going to have to search. I mean, it just seems trite. I can't imagine why I'm repeating this. But that you're going to have to search executions if for no other reason than to be fair to the solicitor on the other side. The last search, perhaps, we're going to do is searches concerning the Planning Act. If we've made this sketch we referred to earlier properly, we should be prepared now to take a look at the abutting property. You should remember June 15th, 67 being the date when all the sins were forgiven with respect to the Planning Act. And you should remember June 27th, 1970 being the date after which part lot control was made to apply to all of the province. When I say part lot control, the use of the word lot is almost a choice of the wrong word, I think, under the Planning Act. So we know that when dealing with the whole of a lot on a plan of subdivision, we're safe. However, many solicitors seem to have confused, and I gather the confusion still exists, township lots and concession lots with lots on plans of subdivision. And of course, they're not the same. And if you're dealing with a township lot or concession lot, then you're going to have to make certain that there has been no contravention in the Planning Act. Also, parts on reference plans are not lots on plans of subdivision. Again, I apologize if I'm talking down to you, but it seems as though that point hasn't been made clearly enough to certain people. Also, one has to remember that the Planning Act requires that you search on all sides. Again, and I bore you once more with recent occurrences in our practice, happen to be dealing with a property in Hamilton where something like 6 or 8 solicitors have dealt with it. It's an apartment building which is selling for several $1 million. And everyone, it seems, had done an exhaustive search in the registry system of all the abutting property. Unfortunately, one of the properties which abut was in the land title system, and no one, it seems, searched that particular parcel. And wouldn't you know it, but that's, of course, where the contravention in the Planning Act occurred. Those 6 or 8 solicitors are somewhat embarrassed and terrified that that's the case, but have no other explanation. As it turns out, it's easy enough to solve, but had my client wished to get out of the transaction because he'd had a change of heart, I suppose someone down the line would be relatively embarrassed by the whole thing. So you should remember that your search may take you into another book and into another system. Also, we've had occasion to deal with expropriations, and what we thought at one point was a situation where there wouldn't be any Planning Act problem has become one. If you're dealing with two entire lots on plan of subdivision side by side, and you find that the front 10 feet is expropriated for some purpose, then obviously when you go to sell one of those two properties that used to be whole of lots, you no longer have a whole of lot on a plan of subdivision. It's not your fault, and I assume that you'd have no difficulty getting the consent if necessary, but I think you're still stuck with a situation where you don't have the whole of a lot on a plan of subdivision. Enough said, I guess, about the registry system. We turn to the other system that we all hate, the land title system. The only benefit of the land title system, I suppose, is it's easy to search in it. Again, I indicated earlier that all plans which begin with the letter M are in the land title system. Each property is itself given a parcel and section number so that you can refer in the abstract. You can find the abstract book for that particular property. And the practice, certainly in the Toronto area, is to get a photocopy of the page or the pages that you're dealing with. It's necessary then to review each of the instruments that affect you. However, unlike the registry system, you don't have to review the instruments for purposes of satisfying yourself that they've been properly executed. What you're concerned with exclusively is whether, in fact, there are terms in the instruments that are going to bother you. Remember, when dealing with the land title system, that there are various exceptions referred to in Section 51. In particular, something like a lease, which is less than 3 years to run, needn't be registered. So that if you're going to be concerned about those kinds of things, you should be familiar with the exceptions to the Land Titles Act. Also under the Land Titles Act, you're aware that the entry does not become final, as it were, until it's been signed by the authorized signing officer. We find that the practice has become to pencil in entries as they're registered, or to type in the entry in a less formal fashion. Again, those entries are subject to being deleted, I suppose, but that's such a rare occurrence that I don't think anyone would suggest that the practice should be to ignore those instruments until such time as they've been initialed by the signing officer. Executions are probably the most, well, if not the most difficult area to deal with under land title system number 3. You should search executions against the vendor when doing your search. Now, many solicitors seem to think, well, the land title system takes care of so many other things, and there are no executions noted on the page, which means, of course, that the prior owners were able to convey without any difficulties with respect to executions, and therefore there's nothing really to bother ourselves about. Well, those of us who practice in the land title system know that it is really quite a difficulty convincing the land title system that given that there's an execution which arises, or which you're made aware of on the day of closing, only because you chose to search on that day, that person is not one and the same as the person who's selling. When we're dealing in the registry system, it's left to the solicitors themselves to satisfy themselves by dealing with the creditor, dealing with the other solicitor, that the particular party we're dealing with is not one and the same as the vendor. However, in the land title system, it's somebody else, some third party that we've got to convince. So that unless we're given the details relating to the executions early enough to prepare ourselves for the inevitable, havoc is going to appear. That's as much as I want to say in a formal fashion, but let me refer you to some of the material in the notes. On page 99 and 98, there's a sample of a chain of title. Again, this is the chain that should be done for each search. Now, with that chain, you can quickly see that there are certain breaks. If you work down from William title, you'll see that the next conveyance is not from William title, but John title, the executor. That conveyance is to someone named Thomas Farmer, but the next deed is from Fred Farmer. Again, a break in the chain. Cowardly Developments Limited becomes the registered owner, but the next deed is from Cowardly Developments, Inc. Again, another break in the chain which is going to be cause for a requisition. I wouldn't suggest that any of the three that I've mentioned are serious breaks in the chain, but again, with the chain of title in your hand, you can quickly review it and see whether there are any breaks that you would have otherwise missed. Moving backwards, if you turn to page 97, there's a copy of the abstract form which Miriam Kelly uses in her office. Most searchers, I think, would find that the search would resemble in part the registrar's abstract, which is on the pages in front. This form of abstract deed is designed to put in front of the searcher enough boxes so that when it's returned, everything the solicitor could possibly want to know about an instrument will be in front of him. And I think it's quite correct to say that if in fact the searcher did fill one of these out each and every time, there wouldn't be any more questions you'd have to ask. The idea, of course, is that you would have a form for each of several types of instruments: a mortgage, a discharge of mortgage, an assignment of mortgage, and so on. Again, if we turn a few more pages, you'll see the registrar's abstract, which begins on page 86. Now, you'll work your way back through the chain to your root of title. And in this instance, our root of title is shown as instrument 2931. You then go back one more step to the Crown patent, which is instrument number 200. You can safely ignore, then, all the instruments which lie between 200 and 2931. Moving forward from the root, that is from 2931, you can also ignore instruments 3101 and 4038 only because they have not been referred to within the 40-year period commencing with their registration. Now, of course, you wouldn't know that when you first look at the search. You'd have to have obviously gone through the search and determined that these instruments hadn't later been referred to. If you look at a couple of other instruments, you'll see instrument number 4312, which is the executor's deed. We've indicated before we're not prepared to accept as a good root of title. Further, it would be necessary under these circumstances to make a search of the general register. As you can see, there is no evidence on the abstract itself to indicate under what authority Mr. John Title is conveying the property on behalf of William Title. Take a look at instruments 5200 and 5265. These are instruments which do not directly deal with the property that we are searching. However, they are portions of the larger property that was initially owned by Fred Farmer, who is one of the predecessors in title. You would have to take a look at the descriptions in each of those instruments to satisfy yourself first that they weren't the descriptions that you were concerned with, and as well to satisfy yourself that there is no overlapping descriptions. Once you've done that, then you could indicate that those instruments were not applicable to this particular search, and you could safely ignore any instruments which would normally flow from them. In other words, if Dempster or Cook were dealing with the property subsequently, we wouldn't need to deal with them. On the next page, just two more items to note. The grant 9371 to Fastbuck is a deed of the property that we're concerned with. As a consequence, instrument 9819, being a grant from Farmer to who else but Red Herring, is something, of course, that we don't have to concern ourselves with because we have satisfied ourselves that Fred Farmer, by virtue of 9371, did convey all of the property that we're concerned with to Fastbuck, so obviously he has nothing more to deal with. Note as one final comment on the actual search itself that the deposit has no registration number. As I indicated before, the deposit is filed and not registered. In sort of brief conclusion, you should take the time to remove yourselves from your daily practice and try to, as best as possible, review your search in the privacy of your office, comparing the search notes with the agreement of purchase and sale and the sketch of survey. Keep yourself aware of the time limits for searching or for submitting requisitions, and make every effort to identify the problem and submit your requisitions on time to avoid the last-minute panic situations which make our practices, which are, at least for me, already intolerable, even more so. Thank you for your attention. Somebody introduce you?
I didn't mean to escape. We have one question. Did you deal with that one question? Okay, we've got one question that one of you has given for Rick to reply to. And after that, we'll have our usual 1 minute stand up and shake, and we'll get going again. You want to see the question? Have you got it? Have I got it?
No, I don't know where it is.
All right, the question has to do with what happens, what liability has the solicitor got if the solicitor hires an outside conveyancing firm and there is a GUFU. Who is responsible, and do we have any dollar limits we have to think about? Thanks, Rick.
Well, as the man said, the buck stops here. No question that you're the one who's initially responsible. However, having hired an outside conveyancer, this would not be considered improper procedure or negligent practice on your behalf, so that you're going to find that your insurance is going to cover your liability. However, the deductible would be somewhat of a problem, and you would, as I understand it, have to claim over against the conveyancer for the deductible. We discussed earlier the fact that the conveyancer can obtain insurance for the deductible. However, it is inordinately expensive, and other arrangements perhaps should be made to make certain that aspect of the deductible is covered.
Thank you, Rick. If there are any questions that you do want for any of the lecturers, if you just write them out, we'll try and get to them when we can, and we'll break for 2.5 minutes.